respondent has received 50% plus 8,419 votes, and accordingly was entitled to be declared elected as the president. So, my Lord, what we are concerned with is when we go through all these irregularities, we shall have to put in the back of our mind that do they go on to the transparency? In fact, the factors to be considered, my Lord, I think is Article 86. Let me just read them so that, my Lord, what is expected of the second respondent is Article 86 state that whatever voting method is used, the system has to be simple, accurate. Accuracy is very important. Verifiable. So it must not only be accurate, but it must be verifiable, secure, accountable, and transparent. That is the constitutional threshold, reducible minimum upon which the first respondent is expected to operate. And therefore, what will tie up your minds as we go on is, looking at all the irregularities we will point out, does it make the elections not satisfy the constitutional threshold set up by Article 86A? That is on one side, my Lord. On the other side, you will be dealing with a mathematical exercise that even if the elections were carried out reasonably properly, and it satisfied all the constitutional threshold, if there is a difference which affects more than 8,419 votes, the elections has in any event to be set aside, and that is a constitutional threshold. It is not a matter of discretion for your lordships. But my Lord, what you have to have in the back of your mind, when a party produces evidence documentary evidence in court, what is it for? Is it a decoration? Is it supposed to be kept in archives and locked there, and then the parties can come and have an academic argument, my Lord? The purpose of filing evidence is so that it can be analyzed. And to the extent that the Electoral Commission has filed its Form 34s and 36s in this court, each and every party is entitled to analyze, scrutinize them, and submit on them before your lordships. Lord, it need not be gainsaid that the client I represent, the petitioner, was dissatisfied with the results and has filed this petition under the provisions of Article 140, challenging the validity of those elections. My Lord, the full particulars of the challenge of the validity is found in the petition, and I will not necessarily go through each and every ground, but my role will be to try and assist my lady, your lordships, to fully understand the main issues which the petitioner is bringing before this court, and to help your lordships understand that they're not flippant, they are grave issues. They go to the very basis of elections in this country. They are important for future elections in this country, and it is important that we address them and stop looking at this issue as a matter between President-elect and my client, Raila-Uhuru. It is more than that. It is the future of this country we should be dealing with. My Lord, let me now go to my first issue, which will detain most of my submission this afternoon. To go on is the process which has been done is very clever. Take a few votes from one candidate, 150, 200, reduce his numbers. Then increase a little the votes of another candidate, and by the end of the day, you have a situation where you end up in a process which achieves the result you want to achieve. That is what happened, and we'll be able to show you that, my lords. And that is why there are these contradictions in Form 34, 36, and when you see one form, it is 50. But when you see 33,000 forms, then it is 50 times 33,000. And in a situation where we are talking of a difference of 8,000 votes. Now, my lord, the following recommendations were made to ensure that these unfortunate events are not repeated. My lord, I will read them because it is important that we bear them in mind as we go to consider what is the position in the case we are dealing with. The recommendations are found at page 148 of the petition, volume 1, and they are that IREC recommended that ECK integrate the various descriptions of the entire counting and tallying procedure into one document only, which will then be the principal description and must be adhered to. The need of such descriptive regulation does not depend on possible changes on the counting and tallying system. So, first issue was immediately change the number of forms. As you remember, on the 2007 election, there were Form 16, Form 17, and manipulations of those forms. So, the intention of this recommendation was to have only one form. And my lord, when you look at that, the regulations, that form was intended to be Form 34. What has now happened? They have now introduced Form 36 as the operative form, and I will show you, very contrary to the law. And it is between manipulation of the figures on Form 36, Form 37, and the final tally that the whole game is played. My lord, the next recommendation was that I recommend that without delay, ECK start having developed an integrated and secure tallying and data transmission system, which will allow computerized data entry and tallying at constituencies, secure simultaneous transmission of individual polling station level data to the National Tallying Center, and the integration of this result handling system in progressive election result announcement. My lord, that is what the first respondent pretended to be doing when all its systems collapsed. And that is what it sold to the public it was doing, and that is what it was, the parliament reduced to the electoral system Kenya wanted to have. My lord, all that is water under the bridge. We are back to manual tallying. We are back to 2007. Then, my lord, the other recommendation was that IREC recommends that ample time be allowed for verifying provisional results so that they are declared final official only once there is no risk that errors may still be found or non-frivolous objections raised. Most countries allow 1 to 2 weeks for this. There must be sufficient time to check the provisional results, which are given status as final results only when all the objections have been considered, all checks and rechecks conducted, and the final verdict issued by the proper authorities. Given a clear explanation of what provisional result is, there is no problem in making voters understand that election results are so important that they can be declared final only once they have been properly scrutinized and checked. My lord, you'll find that at page 172 of the petition, and that is part of the IREC report. So that, my lord, what was anticipated was that in spite of all these electronic means, you would give all parties concerned an opportunity to interrogate whatever returns have been made, make all of the objections they have, and it is only after that is done that you then announce the final result, and hence the provisions of the regulations allowing the IEBC to announce final results only after 6 days of verification, tallying, and finalization. My Lord, that is not what happened. I will show Your Lordship that instead my client's agents were thrown out of the tallying. My Lord, numerous constitutional, legislative, and regulatory steps have been taken to create appropriate framework to overhaul the electoral process, beginning with the establishment of the first respondent as an independent electoral commission and extending to the enactment of appropriate legislation, including the IEBC Act and the Election Act, my Lord. The first respondent was thus established as an independent commission with the mandate to deliver elections which are simple, accurate, verifiable, secure, accountable, and transparent as enshrined in Article 86 of the Constitution. And this is the obligation, my Lord, which once we prove prima facie, and we will be able to prove that there were massive irregularities, and these elections did not satisfy any of the standards which are required, then it is their obligation to satisfy Your Lordship that they carried out an election which fits with the provisions of the Constitution. That burden is not on us. The burden on us is to give a prima facie case that this fundamental article of the Constitution, which anchors a free and a fair election, have been satisfied, my Lord. My Lord, as it were, the first respondent adopted a hybrid system which was partly electronic, partly manual. My Lord, in the promotion of the system to the public, the first respondent presented that the way they were going to carry out the registration of voters was through the BVR system. And my Lord, they sold it by stating that BVR ensures quick and precise voter identification, and it is the cornerstone of any credible election. The system provides the highest voting safety levels and prevents fraud. My Lord, advertisement was done sometime in June 2012. And my Lord, the whole purpose the Independent Electoral and Boundaries Commission was going through this exercise is to ensure that the specter of ghost voters and ghost votes is eliminated from our system. My Lord, the specific objects of this tender is outlined in the tender itself, and it was to provide voter identification and authentication on polling day through the use of biometric fingerprint technology, to provide an effective means of reconciling the number of voters checked in with, and that is very, very important, my Lord, that this technology was ensuring that the voter was identified. But two, it was also going to provide efficient and effective means of reconciling the number of voters checked in with the number of votes cast. So it was checking who came in, he must be registered, and once he votes, then it has to be reconciled with the number which came in. And my Lord, it was also to reduce the human error by election officials and to ensure that the election areas were secured from unauthorized access. And at the end of the day, it was also going to provide, to generate end-of-day reports showing at a minimum the voter turnout, that is the number and percentages of registered voters clear to vote. So that, my Lord, had this happened, we would not be before your Lordship today. Because what we would now do is to know from the electronic records how many people came in, how many people voted, and how do we relate it to the result. And from 34, would only come to verify that. That is what was intended in the process which was organized by the Electoral Commission. Now, my Lord, it will be demonstrated that there were many instances where the voter turnout in polling stations exceeded the number of registered voters as per the register of February 18, 2013. My Lord, we will also show you that the explanation given by the Commission is absolutely unsatisfactory. Having deployed a failed EVI technology, it is then easy for the Commission to wish away the centrality of technology in these elections. My Lord, we will show you that the process started to go in a completely straight path, beginning with the tender, my Lord. The tender was eventually awarded to a company known as Face Technology by the tender committee, despite earlier findings by evaluation committee that it was non-responsive in many respects. And I would wish to refer your Lordship to page 352 of our petition. My Lord, page 352, there is minutes of the evaluation committee beginning at page 350, and 351 shows the number of persons who attended that meeting to evaluate the tenders in respect of EVIT. My Lord, this was what they came up with. At page 352, Face Technology, the firm was represented by Mr. Hunter and Mr. Charles Calliot. The firm system architect made presentation on the functionality of their device. The committee noted that the firm has not met the following specification. My Lord, they then outlined the specifications which have been met. And in fact, they were the most fundamental specifications. In conclusion, the firm did not demonstrate prototype that met the POC requirements as stipulated in the tender document. However, the firm stated that they had received the communication late and were unable to prepare for presentation and provide the relevant prototype. They committed to provide a comprehensive demonstration there in resolution given another opportunity. So, my Lord, this was a firm which clearly failed in the tender evaluation. My Lord, let us have in the back of our mind that the first respondent is required by law to carry out its activities transparently on behalf of the public of Kenya. But, my Lord, that did not stop the mandarins at the first respondent's place. On 31st October, a meeting was called of the tender committee under the chairperson, Betty Sungura, and a couple of others.